Workplaces are not only about contracts and salaries, sometimes they are about conflict. An employee might say, I was dismissed or fired unfairly. A manager might complain, the union is refusing to cooperate. A company may face a claim of harassment or discrimination. As lawyers, we must explain the process of resolving workplace disputes clearly, step by step. In this lesson, we will explore how disputes begin, the vocabulary for different types of conflicts, and how lawyers guide clients towards solutions like mediation, arbitration, and settlement. We'll also practice using modal verbs like should, must, may, ought to give advice and explain obligations in these contexts. This is part of our full legal English course for lawyers and legal professionals. Full lessons, live sessions, and expert support. Join our community. The link is in the description. By the end of today's lesson, you will use vocabulary like grievance, mediation, arbitration, discrimination, harassment, unfair dismissal, settlement, and collective bargaining. You will use modal verbs like should, must, may have to, ought to explain obligations and give advice. You will apply legal phrases such as file a grievance, resolve a dispute, reach a settlement, bring a claim for unfair dismissal, and use key expressions like duty of care, equal treatment, hostile work environment, and good faith negotiation. This will give you the tools to explain workplace conflicts in clear, professional English. Let's begin with the story. In a company in Ireland, an employee believes she was dismissed unfairly. She tells her lawyer, I want to fight this. What can I do? The lawyer explains the steps using clear sequencing. First, you should file a grievance with your employer. This is the formal way to raise the issue. Then, if the grievance is not resolved, the company may suggest mediation. This means a neutral person helps both sides talk and find an agreement. After that, if mediation fails, you may have to go to arbitration or even court. Finally, if you win, you could reach a settlement or even be reinstated. The lawyer also explains rights. You must be treated with equal respect under employment law. The employer ought to show a duty of care towards employees, and both sides should negotiate in good faith. This story shows how legal English helps us explain workplace disputes step by step, not just the problem, but the possible solutions. A grievance is an official complaint raised by an employee. It can be about pay, safety, discrimination, or treatment at work. For example, the employee filed a grievance about unsafe working conditions. Let's look at a story. A nurse in a hospital feels her shifts are unfair and unsafe. She files a grievance with management saying, I am being asked to work 16 hours without proper breaks. The lawyer explains a grievance is the first formal step to raise problems. It shows that the employee followed procedure before taking legal action. Grievances are the starting point for many workplace disputes. Mediation means using a neutral mediator to help both sides talk and find a solution. The mediator does not decide, they only guide the discussion. For example, the dispute went to mediation instead of court. Let's look at a story. A teacher claims she was harassed by her supervisor. Instead of going to court, the school suggests mediation. The mediator listens to both sides and helps them reach a compromise. The lawyer tells the client, mediation is faster and less expensive than trial. You should consider it before going further. Mediation is a common resolution tool in employment law. Arbitration is stronger than mediation. Here, an independent arbitrator listens to both sides and makes a binding decision. For example, the union agreed to arbitration to resolve the contract dispute. A group of factory workers argue with management about wages. After failed mediation, the case goes to arbitration. The arbitrator decides the workers will receive a 5% raise. The lawyer explains, unlike mediation, arbitration produces a final decision that both sides must accept. Arbitration is often used in labor disputes and union negotiations. Discrimination happens when someone is being treated unfairly at work because of personal characteristics like race, gender, or age. For example, she filed a claim of discrimination after being denied promotion. Let's look at a story. A 55-year-old employee is repeatedly told she is too old for leadership roles. She is denied promotion while younger, less experienced workers are promoted. Her lawyer explains, this is age discrimination. You have the right to equal treatment under labor law. Discrimination is one of the most common sources of workplace disputes. Harassment means repeated or serious unwanted behavior, bullying, sexual comments, threats that make the workplace hostile. For example, the company faced a lawsuit for workplace harassment. Let's imagine a story. An employee is constantly mocked by colleagues for his accent. Another receives repeated unwanted messages from her supervisor. The lawyer explains, both cases are harassment. The law protects employees from hostile work environments. Harassment cases often lead to mediation, settlement, or court claims. Unfair dismissal means an employee was terminated in violation of labor law without cause, procedure, or fairness. For example, the worker brought a claim for unfair dismissal. Let's look at a story about a receptionist. A receptionist is fired suddenly without warning, even though her performance was good. The lawyer explains, you may bring a claim for unfair dismissal. The employer must show a valid reason and follow fair procedure. Unfair dismissal is one of the most serious disputes between workers and employers. Collective bargaining happens when a union negotiates with management on behalf of many workers. The union entered into collective bargaining with management. Let's take a look at a story. A union representing bus drivers demands higher wages. Management refuses at first, but later meets with union leaders. They agree to a 10% raise after weeks of collective bargaining. The lawyer explains, collective bargaining protects workers by giving them a stronger voice in negotiations. This term is central to labor law worldwide. A settlement is when both sides agree to end the dispute without going through a full trial. It often involves compensation or specific terms. For example, the parties reached a settlement before trial. Let's look at this story. An employee sues for harassment. Before the case reaches court, the employer offers financial compensation and promises new workplace policies. The employee accepts, and the lawyer explains, this is a settlement. Both sides avoid the cost and uncertainty of a trial. Settlements are very common in employment disputes. In workplace disputes, lawyers often give advice, not orders. For this, we use should or ought to. Both mean it's a good idea, but not an absolute requirement. For example, you should file a grievance first. This is advice for the employee. Or, the employer ought to consider mediation. This suggests the employer take a positive step. Let's look at a story. A worker says, I feel discriminated against. What should I do? The lawyer replies, you should file a grievance with HR. You ought to keep a record of all incidents. That way, you have evidence if the case goes to arbitration. These modal verbs help us give professional recommendations without sounding too strong or forceful. Sometimes the law requires action. For this, we use must. Other times, the action is not certain but possible. Then we use may have to. Let's look at example 1. Employers must provide a safe workplace. This is a strict legal obligation. Or example 2. You may have to go to arbitration if mediation fails. This shows a possible requirement. Let's look at this story. An employee asks, "Can I refuse to return to work if the conditions are unsafe?" The lawyer explains, "No, your employer must provide a safe environment. If they fail, you may have to bring a legal claim." These modal verbs allow us to explain rules, duties, and possible next steps in workplace disputes. To file a grievance means to make an official written complaint about something at work. Unsafe conditions, unfair treatment, discrimination. For example, the employee filed a grievance with HR. Let's look at a story. An office worker feels harassed by her supervisor. The lawyer advises, first, you should file a grievance. This starts the formal process and shows you tried to resolve the issue internally before going to court. Filing a grievance is often the first legal step in workplace disputes. To resolve a dispute means to find a solution through negotiation, mediation, arbitration, or court. For example, the parties resolved the dispute through mediation. Let's take a look at this example. A group of workers demand higher pay. Management refuses at first, but after mediation, both sides agree to a 5% raise. The lawyer explains the dispute was resolved fairly. Neither side had to go to court. Resolving disputes is the ultimate goal of labor law. To reach a settlement means to make an agreement that ends the dispute without a full trial. For example, the company reached a settlement with the dismissed worker. Let's look at a story. An employee claims discrimination. Instead of a long trial, the employer offers financial compensation and a promise of new workplace policies. The employee accepts. The lawyer explains, you reached a settlement. This avoids the cost and risks of court. Settlements are very common in workplace disputes. To bring a claim for unfair dismissal means to start legal proceedings because an employee was fired without fair reason or without following procedure. For example, the worker brought a claim for unfair dismissal after being fired without notice. Let's look at this one. A store clerk with excellent performance is suddenly fired because the manager wants someone younger. The lawyer explains, you can bring a claim for unfair dismissal. The employer must prove the dismissal was fair and legal. This phrase is critical in employment law. It protects workers from being dismissed without cause. Employment law uses some key expressions to describe rights and duties in workplace disputes. Duty of care. Employers must protect the health, safety, and well-being of staff. For example, the company failed in its duty of care by ignoring safety rules. Equal treatment. All employees should be treated fairly without discrimination. An example, the court found the employer had violated the principle of equal treatment. Hostile work environment. Harassment or intimidation that makes the workplace unbearable. For example, repeated insult created a hostile work environment. Good faith negotiation. Both sides must make an honest effort in resolving disputes. For example, the union accused management of failing to negotiate in good faith. Constructive dismissal. When conditions are so bad that the employee resigns, but the law treats it as unfair dismissal. For example, the worker claimed constructive dismissal due to constant harassment. Industrial action. Collective worker actions like strikes or work stoppages. For example, the employees took industrial action after failed negotiations. These expressions allow you to explain not only the conflicts, but also the principles of fairness and resolution in employment law. Let's bring everything together with a real-life story. A factory worker in Germany is suddenly dismissed. He feels it was unfair and goes to his lawyer. The lawyer explains step by step using modal verbs in key terms. First, you should file a grievance with the company. That's the formal way to start. Then, if the issue is not resolved, the employer may have to attend mediation. Both sides ought to negotiate in good faith. After that, if mediation fails, the case could move to arbitration or even court. Finally, it's possible to reach a settlement before a full hearing. In this case, the lawyer highlights the worker's rights. Your employer must respect the duty of care and the principle of equal treatment. If they fail, you can bring a claim for unfair dismissal. After mediation, both sides agree on compensation, and the worker is satisfied. The lawyer concludes the dispute was resolved fairly without going to court. This story shows how vocabulary, grammar, legal phrases, and key expressions all work together to explain workplace disputes in clear legal English. Let's review today's lesson on workplace disputes and resolutions. First, we practice vocabulary, terms like grievance, mediation, arbitration, discrimination, harassment, unfair dismissal, collective bargaining, and settlement. These words describe the most common workplace conflicts. Second, we focused on grammar, modal verbs, should and ought to for giving advice, must for strict legal obligations, and may have to for possible requirements. Third, we studied legal phrases. File a grievance, which means to start a formal complaint. Resolve a dispute, to find a solution. Reach a settlement, to be able to agree before trial. Bring a claim for unfair dismissal, which is to challenge a wrongful termination. Fourth, we explored key expressions, duty of care, equal treatment, hostile work environment, good faith negotiation, constructive dismissal, and industrial action. These terms explain the principles behind employment law. Finally, we told a wrap-up story of a worker who was unfairly dismissed. We saw how the lawyer explained each step, from grievance to mediation to settlement, using modal verbs and professional legal English. Now, you can explain workplace disputes clearly, showing both the process and the rights involved. Workplace disputes are just one part of employment law. For full lessons, live sessions, community support, join our Legal English community. Click the link in the description and keep building your skills.